For the next few questions, I want you to put up your Zoom hands if you answer yes to these questions. And keep them up if you keep answering yes to these questions. The first question, have you ever thought, how do I ask my professor for an extension on a project submission? Do I see a few hands up? Okay, the next question. How do I convince my friend to go out to my favorite restaurant for dinner? I see a few more hands going up. How do I persuade my parents to finally allow me to go on that very much needed Goa trip with my friends? All right, another, okay, more hands coming up. And these questions never stop, no matter what your age is. I mean, how do I ask my boss for a raise? How do I get the best deal on a car? These questions come up in everyday life, and the answer is fairly simple: negotiation. Negotiation is not some abstract concept only fit for movies when you see a hostage negotiator top down a terrorist holding the president's son. No, negotiation is a part and parcel of our daily routine. Even talking with your parents about your curfew time requires negotiation skills. But of course, we all know that only the toughest and the smartest negotiation win that conversation. But to further explore this application of negotiation in real life, we have invited two of the most renowned negotiators, not nationally, but globally, Miss Anna Sambold and Mr. Matthew Rushton, to help us better understand this approach to daily life negotiation. I take great pleasure in introducing Ms. Anna Sambold. She is an advisor on the Curia International Global Advisory Board. She is a highly efficient mediator and lawyer at the American Bar Association. Anna is fully bilingual and is currently the co-chair of the State Bar of California Civil Litigation Section's ADR Committee. As a powerful and independent woman who has her own mediation practice in California, Anna can offer us an insight on how the world perceives female negotiators and how she came about not following the traditional path of lawyering, but decided to pursue mediation and negotiation. Welcome to the panel, Anna. It's wonderful to have you today.
Thank you for having me.
I take great pride in introducing our second panelist, Mr. Matthew Rushton. Matthew is a former journalist turned author and entrepreneur. Matthew is the EMEA director of JAMS, a world-renowned ADR firm. Following a number of alternative dispute resolution related business ventures, he initiated the JAMS London office in 2011. Matthew is a dispute resolution related, Matthew is an expert in the business angle of negotiation. Matthew can guide us through the qualities needed to deal with a tough negotiator, what qualities he finds essential in a business partner, and what makes a great daily life negotiator. Matthew, your career path shows a great passion for ADR, and we hope to learn the importance of negotiation in the world of business from you. Welcome to the panel, Matthew. It's a pleasure to have you here.
My pleasure. I shall do my very best. Thank you.
Without further ado, I am going to launch into the questions. Before that, I request any of you to have any questions, pop them up in the chat box or raise your hand. They just help me out. If people do have questions, let me know and we can, of course, ask them to unmute and ask their questions. My first question is a very generic one. You both have years of experience in ADR. What made you choose this path instead of traditional lawyering? Anna, if you may go first.
I was hoping Matthew will go first.
I
guess there's no negotiable, right? I started mediating 10 years ago. And by the way, I had an international business law background, and at some point I remember reading something about mediation and the benefits of mediation, and I was very curious about trying. And once I tried, and I realized how effective and how efficient was, and how practical it was, I'm a very practical lawyer, and I guess that is one of the things that I really like about mediating and negotiating directly with the parties is that it saves you a lot of time, it saves you a lot of money, and since that I was hooked into mediation, and I believe negotiation is just a big part, and I guess everything is negotiable in life. The difference is how difficult is going to be the negotiation. Some things in life are easy to negotiate, and another ones are not that easy. That's how I become a mediator, and I love everything related to negotiation.
That's very interesting. Thank you, Anna. Matthew, what was your aim and motivation behind the ADR field?
That's it's an interesting question. So I came to ADR via a slightly strange route. I was, as you mentioned in your introduction, a journalist, and I was a legal reporter. And I got sent off to the courts regularly to report back on matters. And I did this for several years. And I learned a number of things in the course of observing a lot of litigation and having to write about it. First, I think I could see the distress that litigation causes litigants. And it doesn't matter who they are. It doesn't matter if you're a CEO or a litigant in person. It's a very distressing process. And I also got an appreciation of, I think, some of the complexities of litigation, which are just not apparent to people, business people, ordinary people who may be perfectly good at negotiating and earning money and doing all these other things. But when they get into that machinery of litigation, they're suddenly lost. You know, they have a good idea in their heads as to what they think this matter is about. You know, it's their dispute ultimately, but they are left at the back of the court. It's taken over by advocates, and anything that they might want to discuss, they're told, you know, this isn't in your witness statement, it's not been pleaded, it's not relevant, it's inadmissible. You go to the back of the court and you stay there, we'll handle this. And you can see the loss of control. And so when I discovered mediation, this looked to me like a very sensible, very pragmatic way of dealing with all of these things. And this was about 20 years ago. I got commissioned, in fact, to write a report on mediation advocacy. And I think that this was the second thing that got me involved in mediation. I was very privileged, I think, to go and interview a lot of the UK's leading mediators at that time. And there were some really remarkable people involved. I got to interview Henry Brown, who was one of the pioneers of mediation in the UK. He was Nelson Mandela's lawyer when he was imprisoned on Robben Island. Another guy that I met and got to know well was David Shapiro, who was a Watergate attorney. And so suddenly in London, we got all these people from all around the world, all pushing in the same direction. And I think what I found so touching was their evangelical fervor. They really wanted me to understand this and to broadcast this message and to get involved. And so I did. I went from there to setting up a magazine and a feedback repository and a mediation directory and so on and so forth. And here I am now. I think what I've learned in the course of all of that is that this is a marathon and not a sprint. I think everyone has that sort of evangelical moment and they want to go out and tell people about it. And I think everyone thinks, you know, in 18 months' time, everyone's going to be doing this. That's not quite happened yet, but I live in hope. So that was my route into it all.
You both spoke about how mediation negotiation brings about party autonomy. It gives the clients more power to decide what goes on with their dispute. In a lawyer-client relationship, do you think negotiation or negotiation skills exist while a lawyer deals with the client, be it in mediation or be it in court?
I think it's absolutely essential. there's a lot of talk these days about emotional intelligence and understanding people and listening. And that, I think, to a huge degree, separates successful lawyers from those who aren't. We can see that law firms all recruit that sort of top 1% slice of the best performing law graduates, but the performance between partners is all over the place. And you have to wonder what it is that separates that. And I think this sort of emotional intelligence is part of that. And in some ways, it's kind of antithetical to the lawyer's mindset. If you think about litigation, classically it's an era, rational inquiry into the truth. That's what we think we're engaged with, and we're dealing with facts, we're dealing with process. And I think that's how we're encouraged to think about litigation. But I think what becomes obvious over time is that far more determinative than the substance and the process is in fact the emotions. And I think the better able you are, the more alert you are to those things, the better able you are to negotiate them, the more successful you will be in generating that empathy and understanding and that teamwork that I think is critical to success.
Matthew, if I've understood you correctly, you've described teamwork, you've described active listening as two essential skills that lawyers must possess in order to become, well, good lawyers and maintain that relationship with their client. Anna, my next question is to you. How do you manage to build trust and get your client to forget about the godly figure of a judge that many people recognize as only the right way to resolve an issue?
Well, I guess establishing rapport with the client and with the parties involved in the dispute is the first step. If they don't trust you, they won't like you. They won't let you help you. And I agree with something that Matthew was mentioning about emotional intelligence. And a big believer that emotional intelligence is probably the most important quality in a mediator or in a negotiator, and every lawyer. And I was amazed that recently I was reading an article about emotional intelligence, and they were saying, do you know what is the profession with the lowest emotional intelligence from all the professions? Do you guys have any idea?
Lawyering profession?
Lawyers. And that is pretty, that is, well, lawyers in general. And that is something that is, I guess it's very concerning, especially when you're helping people or you're helping them to negotiate. Because if you have that emotional intelligence, that means that you have that awareness, that intuition that allows you to know when to say the right thing and come up with the find out what are the other side's interests and how to meet their interests and how to satisfy your own and how to find that win-win. So if you don't have that awareness, if you don't have that intuition and you don't have those skills, that it will really affect any negotiation you have in life. So that's what I will say, that having, but the good news is that emotional intelligence, unlike IQ, is something that you can improve in life. And I guess you can take different trainings in different ways and find out more about it and improve that. And once you improve that, I guess a good negotiator at the end is somebody that is very is a good collaborator and is aware of the other side's interests and needs and emotions and know how to handle that in general. And so if you can improve those emotional intelligence skills and you can work around that, you can become a really good negotiator. And and either as a mediator or as a negotiator, you establish good rapport with the parties, they will trust you, and you will be able to assist them in the negotiation effectively.
Well, that was quite a set of skills which you laid out for us, Anna, regarding what skills you would expect in a mediator or a negotiator. I now move the conversation a little bit more towards what are the kind of skills that you are looking for as, say, an employee or a recent graduate who wants to join your firm, whether it be for mediation, whether it be as within your business firm. And Matthew, I aim this question at you. What are the skills that you look for before hiring people in your firm?
It's a very interesting question, and it I think it relates a little bit to your previous question about the godly judge. I think that the fact is, for mediators, there is a very broad span of competencies that you can, I was going to say, get away with. But, you know, the remarkable thing to my mind about mediation is that as a process, it's so successful that I've seen successful mediators that don't have the full toolkit, that aren't good at reading the room, that aren't necessarily terribly empathetic. But if you can compensate for that with, you know, a tremendous background, great charisma, power and so forth, you have an air of authority about you, people will want to listen to you, you get to approach the mediation in an entirely different way to somebody else. So I look very carefully at a broad range of things when we're recruiting people. The J in JAM stands for judicial. We were founded by a judge, and it's I think remains the case, certainly in California, that retired judges are very sought after mediators. I think it's less the case on the east coast of the States, and it's even less so in London, where I think it is thought that the skills and attributes you need to be a judge set you apart and are very, very different to what's needed from a mediator. That said, we tend to recruit almost exclusively from lawyers, and that's not because I believe that the skills of a good mediator are necessarily those of a lawyer. I think that they're separate competencies in many ways. But I think the reality of the market is, for us in London, is that the solicitors are the gatekeepers, and they have that natural human tendency to appoint in their own image. They will want to use other lawyers, you know, barristers or solicitors. And I think it's often seen as an unnecessary risk to get somebody without legal qualification to hear some of the cases. And it's next to impossible if you can't command the trust of those solicitors to build a practice. So for those reasons, we recruit from lawyers. And I suppose there's a question of what attributes we're looking for. You know, those soft skills must be there. You've got to be able to read a room. You've got to have emotional intelligence. You've got to have empathy. You've got to be a very resilient character, not only in the room, but to build a practice. You've got to persevere over a long period of time to build there. You're going to have to take a lot of rejection. And besides those sort of personal attributes, you need to have, you know, it shouldn't be the case, but you need to have enough charisma to get people to actually talk about you. It's not a straightforward sell, becoming a mediator. It's not a question of meeting one person and closing the deal. You've got to meet hundreds of people, because on every mediation agreement, as you know, there are 4 signatures that the representatives and the clients on both sides. So it takes a long time for that to percolate through. And it's not helped by the fact that it's a confidential process. You can't, like you would with a barrister, just go and see them operate in court. And you only ever get a one-sided view of that mediator when they're off in the other room. You can't and don't know what they're doing. So it's a whole combination of things that are intrinsic and extrinsic to your practice of a mediator.
Well, Matthew, one thing which was very interesting to me, and you said that, is it takes experience for these skills to kind of build up. And of course, mediation being confidential in most cases, it doesn't help that nobody can actually see you in practice. So Anna, as an experienced mediator, what are the skills that you young advocates
I know. Well,
or build up
aware
of that?
How do be very realistic that be hard and complicated, and that was my mentality when I started mediating. And I realized this is gonna take a while. It is gonna be complicated, but you can make it. If you invest a lot of time and money and I will say that, first of all, get all the training that you need to. I basically, when I decided that I wanted to become a mediator, I took every single mediation training existent in the world. I went from my local mediation training in San Diego, here in San Diego, to Pepperdine University, to Harvard, to Columbia Law School, to the Charter Institute of Arbitrators. I took every single training, and nowadays I'm still taking continuing education, and I still taking different trainings. And then when you start getting cases, just do a really good job, and in that way, those clients, if they're happy, they will refer you to more clients, and that's what happened. And eventually, you start getting busy. But one of the interesting things that I remember reading in a book, because when I started it, I read every single book about establishing your ADR practice, and I remember that it was Woody Moston, how to establish your mediation practice, and he was saying that it takes at least between 7 to 10 years to establish yourself as a mediator. And I was very surprised, but you know what? I think so. That's what happened. And I was reading in another book about how half of the qualified mediators in the States, they have zero income. So that is just to tell you how hard and how complicated it is. And so you can call yourself a mediator, you can train yourself as a mediator, but becoming successful and getting cases and making money and be able to pay the bills out of mediation, that's another story. That's what is hard and complicated. So that's where you had to be very persistent. You really had to work hard and invest a lot of time. I think so what you're doing, for example, and that's what I really was impressed with you, because you right away, you're a law student and you really dive deep into the negotiation competitions. You travel all over the world. You get to meet people involved in mediation. You get to know the thing. You founded the Curia International, and you provided this amazing platform for all the students all over the world to promote ADR and mediation and arbitration. I think so that's a great thing to do. And that's a great example of how somebody can start getting into the field and just make yourself known and start creating and building your resume, a good and impressive resume that it will stand out in the future when you start practicing as a mediator. Those are my recommendations.
Thank you so much, Anna, for those kind words. And of course, for the very realistic picture that you've given us. It's all fun and games to say that I am an accredited mediator, but if I go out and practice and I ask people to refer cases to me, I doubt how many people would actually choose me as a mediator. And that's okay, because I've seen from, well, of course, experts like you, that it does take a lot of experience and time to actually build up to that level wherein you are mediating real life cases. And I think this is a good point for us to turn to the question that how do we use these skills in real life? How do we apply these negotiation skills in real life, if we apply them at all, in fact? So in fact, my question goes out to both of you. Do you think that your profession has ever proved handy in real life? The kind of skills that your profession has given you, have they proven handy in real life? I can see Anna nodding, so I'm going to go to you first.
Well, yeah, I find myself sometimes rephrasing and summarizing what my kids just told me when they're having, when they're fighting over something. So, or my husband too. And he responds sometimes like, "Don't try to mediate me. No way, it's not gonna work with me." So yeah, once you know those skills and once you start doing it, obviously you can't forget about it. So you just start just practicing what you know and trying to apply it to everything around you, your kids, your husband, your friends, your colleagues, and everywhere. So yeah, it's something as you were saying in the beginning of this presentation, that negotiation is a part of life. Every day we're negotiating, and as a mediator, obviously you are just more specialized, and you're a professional in negotiation. So obviously is going to come out in every single aspect of your life. That is no way around.
That was a very interesting response, given that I feel that personal negotiations, when it comes to family and your own parents and kids and siblings and all of that, I think those are the most difficult negotiations, because there's a lot of emotion at stake, and it's very different from business negotiations when you're there with a particular agenda in hand. And
well,
Matthew,
I have something to say that I would say that, you know what, even in my most complex and complicated business negotiations, I always find that emotions are involved, always. And sometimes, and it's so funny because I recently mediated a case that it was a business dispute between two partners. And you don't imagine how emotional they were about every single aspect of the negotiation, because what I was trying to do was help them with the business divorce. That's what I call them, business divorce, where they're going to have to separate and divide everything that they have. And one person was taking the name, another person was taking the stores, and they were taking, it was a restaurant, so they were taking some of the recipes. And you don't imagine how emotional it was. So my take on that is that I think so every single dispute in life, doesn't matter how business or how commercial or serious look like, you're always going to have to deal with emotions. And that's what I say, if the mediator or the negotiator or whoever is involved in helping them to resolve the dispute has to be aware of that, and they need to know how to handle the emotions involved in a dispute, and they need to be aware of that, and they need to be sure that they manage those emotions. Otherwise they're going to have a hard time resolving them. It's like trying to build a house without the foundation, so you have to deal with that.
Matthew, what's your take on that? Have you witnessed similar emotions cropping up in business negotiations?
Yeah, I absolutely agree with that. I mean, we make our decisions, we process everything through the limbic system in the brain, which is the emotional center. So when we tell ourselves we're making perfectly reasonable, rational, considered decisions, they're often just emotional reactions. And what we're doing is retrospectively justifying the decisions that we've already come to. We're actually a lot less in control of the decisions and so forth that we make than we all like to suppose. And I've been fortunate over the years to observe a lot of mediations with different parties in different countries in different parts of the world, and it manifests itself differently, but they are all emotional. You know, even if you think of the most dry kind of insurance coverage dispute where you've got professional litigators on either side, there's still an emotional investment. The claims handler for the insurance company, there's a reputational issue there for them. They need to impress their bosses. They need to get the best deal that they can. It's still, you know, it's still emotional. I mean, they will all turn around at some point in the mediation and say to the mediator, you know, the line out of The Godfather, you know, this is just business. But you know, it really isn't. It's everybody feels it, and you know, and I think that's a good thing, because I think once you start to filter those emotions, bring them to the surface, and work with them, that's where you start to I think really make some progress in negotiations. And I think that this is, you know, when you're taught about mediation for these competitions, we're very much sort of focused on interests. If I can understand your interests and I expand on mine, we will somehow rationally come to a deal. You know, does that really convince? I mean, the reality of all of these negotiations is that they are a lot messier, a lot crazier, a lot less predictable than interests would suggest. There's an assumed rationality there when you're talking about interests, that if you can understand where I'm coming from, you'll accommodate, you know, whatever it is that I want. And then everyone's terribly frustrated when that doesn't work out. And it's really the emotional dynamic. You know, I need to hear and understand your crazy suggestions in order to be able to accommodate them, to come to a deal. So let's get this stuff out, you know, up in the air, up to the surface, and then deal with it. And I think I don't know what Anna's experience has been, but virtual mediation over Zoom, I think everyone was terribly concerned at the start that this kind of emotional content that you pick up intuitively, it's there in people's body language, it's how they throw their briefcase on the table, kick the chair, you know, whatever they do, you're not going to be able to see all that over Zoom. And I think there was a concern that dynamic would be missing from online mediation. But I think that's proved not to be the case. I think this kind of face-to-face dialogue, such as we're having now, you can actually read people's expressions a great deal easier than you can, you know, looking at the side of their nose on a conference table or something. But it's absolutely central.
Well, that's very interesting, Matthew. Two things that you mentioned which really caught my attention was, one, how these competitions sort of go about in a very collaborative manner, wherein both parties are there at the table to somehow settle and figure out each other's interests. But that's not how real life negotiations work. I mean, I've been in multiple of these competitions wherein the judges have said that this was probably the most collaborative round that we've seen. But this isn't how real life negotiations actually work. You know, people are very adamant, they're tough, they want to stick to their stance, they want to go out feeling like they won the conversation. What is your take on these kind of tough, never yielding, never concealing model of a negotiator? Is it frequently something which happens in real life? Does it work? Does intimidating another party work?
Anna, do you have something to say? But if not, I'm happy to speak on this.
I wouldn't be so quick to assume that in every that the competition, the format about that everybody's here is so collaborative and that doesn't happen in real life. I wouldn't be so quick to say that. Because you know what, I assume that if the parties are coming to to a mediation, for example, they both want to try to settle, and for how much, that's the point, that's the problem. And how complicated it's going to be, well, that's the difference. But I think that in every negotiation, in every mediation in real life, if the parties come to the table and they both agree to negotiate or mediate, you can assume that both deep inside they want to try to settle. And in a competition, obviously, that is the whole goal, right? The students, the instruction is, look, you had to settle this case and you had to reach an agreement. So both teams are going to come to the competition with the idea like, okay, we need to get to we need to reach an agreement, but we have to figure out how. We need to figure out what they want and meet our interests and meet their interests, and there we go. So I think that is applicable in real life too, and is about finding out what they want and finding out how you meet your own interests too at the same time. But I will say that if they come to the table, if they decide to mediate or they decide to negotiate, deep down, everybody wants to settle.
Could
How
I
far is
offer
it going to be? Well, yeah.
an alternative view? I'm always a little bit taken aback in the gulf between what happens in competitions and some of the things that I've seen observing mediations. You know, we teach people that the way to get the best deal is to understand and be conciliatory and collaborate and you know, respond appropriately and so forth, and certainly that works. But it can also be remarkably effective to do none of that. Just to lay out your stall and not budge. That's it. That's my final offer. And never move, not engage at all. And you sit there, you know, looking at your laptop, and every time an offer is put to you, you just say no. And you've anchored the other side on a particular number. And so, you know, we need to be a little bit careful about what we start to define as effective negotiation. I think your original question about, you know, being mean and nasty, you know, being belligerent for the sake of it, does that impress anyone? Does it intimidate? I think it will intimidate some people, but I think, you know, when you're dealing with professional litigants, they've seen it all before. They're not bothered. It's beyond question, if you go in looking for a fight, you will get a fight. And I think there is evidence that in doing so, you won't come away with the best possible deal. I think you would likely do better. But it just pays, I think, to keep in mind that not everyone's done this sort of mediation training. They all come to mediations with their own ideas about what's successful. There's a lot of theatrics, a lot of drama, I sometimes find. And some of this, I think, is cultural. We Brits, I think, are viewed as rather slippery. There's a lot of subtext to the things that we say. I think we're seen as slightly disingenuous often by you know, Americans in particular, who tend to be a little bit more direct, a little bit more straightforward. And in turn, we look at the Americans and some of the negotiation that the US lawyers go in for. And it all looks just a little bit too dramatic for you know, our tastes. And we've had mediations that have terminated after 90 minutes. People have flown in from halfway around the world, and they've stormed out. And you know, you've got to be prepared for that to happen. That, you know, the mediator can plead with them, but they're going to go anyway. But what you don't know when you witness behaviour like that is quite what the game is. What is happening here? Do they blow up this mediation now because further down the line that there's something else? You know, you might lose here but gain something out. There's a lot there that you have to bear in mind, and so, you know, it takes all sorts, and it's not always visible to you what's going on. But certainly, you know, if a counterparty spots any weakness and they think being belligerent and difficult will help them achieve their goals, they're going to do that. You know, whether or not it may or may not suit them to settle. I mean, to Anna's point, I'm a little bit skeptical. Very often, the defendant wants to string this out for as long as possible. Why have one mediation when we could have 3 or 4 and stretch this out for another 18 months and not pay out?
That's what is important, to be very persistent and very patient in every negotiation. Because obviously, I start every single mediation, every single case that I have, with the 2 sides at the opposite side of the spectrum. They always start with an outrageous opening demand, and the other side is offering a penny. And everybody's insulted and everybody's offended and not moving. And that's why a good mediator and a good negotiator can be super helpful, because they're just going to help the parties to stick to the negotiation and keep going and keep the negotiation going. It doesn't matter how hard and how look both parties are at the beginning. And you just need to keep the negotiation going and be persistent and be patient and be optimistic, because people sometimes go like, yeah, this is a big waste of time. That I hear that all the time. Oh, there's no way. That is just offensive. That is just insulting. I am leaving right now. This is it. And I hear that all the time. But you know what? 14 hours later, 10 hours later, whatever, we get a deal. So
that seems to me a critical competence of a mediator. That sense of optimism, knowing that all this posturing isn't necessarily going to blow the whole thing up. I think on many occasions when I'm observing mediations, not being a mediator myself, you turn and look at the mediator and you think, this is hope. Let's just pack our bags. Let's just give up now. This is hopeless. And the mediator will then gather up their papers, bounce out of there, and say, "Thank you, gentlemen. This has been most constructive. I'll be back to you shortly." And keeping that body language, that energy, that sense of optimism.
You have to, yeah.
You have to, and it's that's a part, I think, of this sort of experience-based skill. You need to have seen enough mediations to know that settlements can arise out of anywhere. You don't necessarily know, or you can't really steer the parties, but they will arise. There will be opportunities, regardless of how much blood there is on the carpet. Ultimately, they may very well get there, or they may not.
Well, Ananya, if you'll permit me to just ask one question, if that's okay with you.
Sure.
Thank you. So I think to her question, I think Anna and Matthew, you both gave very amazing answers. Like Anna took the stance saying that people coming to a mediation, would have to view that they wish to settle. It's just about the amount. And then Matthew painted a picture on the flip side saying that, that's not always true. There are some parties that come in with a hard stance. So in both these positions, when you talk about a mediator or a moderator, see, in theory, we see that the person in this position, acts as a facilitator and someone who just helps the discussion move from one direction to the other. But I just want to ask, when it comes to the reality, do mediators or moderators provide solutions or actually create a framework of how things would happen? Or they're actually, within, in between the parties trying to solve the dispute, giving out suggestions of their own? How does it exactly work?
Well, as a mediator, I try to use every single tool in my toolbox to help the parties. And like I said, in every single case that I have, they always start in the opposite side of the spectrum, right? So I just had to be creative, and I just have to use every single possible question, argument, legal claim, anything to keep the negotiation going, to keep the people engaged and persuade one side of the weaknesses of their plan, or being creative and coming up with different options, of being asking them, okay, so what about if we do this? What about if we do that? What about if instead of doing this, you do that? And just offering solutions, that's part of one of the mediator's role. And I think a good mediator should be creative and should come out with different ways that the parties can just negotiate their way through a complicated case. And I guess that's one of the greatest things about, especially about mediation, that you can be creative and you can play with different aspects of the dispute, the personal, the legal, every single aspect, and the whole. And I think this is wonderful that a mediator just have the whole picture of what's happening, is listening to one side, is listening to the other side. So obviously had really a good overview what's happening or what's really going on, and depending on the dynamics, it can propose and can deliver some solutions that probably the parties didn't have the chance to see because they were so immersed into the dispute that they didn't see it. So I think so a good mediator should propose different ways to resolve the case. And it's interesting because the last week, for example, I was giving a class in Mexico City to mediators, court mediators, and they were telling me that in Latin America, they have two concepts. They have mediation and they have conciliation. And the difference between the two concepts is that the conciliator is allowed to offer different ways to resolve it. The mediator, they don't. And like I was just, wow, that's pretty amazing to me, because so they're basically the same person, but at some point they become conciliators when they start offering different or proposing different options to the parties. And that is a big, huge difference in Latin America between the two concepts. We don't have that here in the States.
Okay.
We don't
It's
have
actually
that here.
similar in India as well. We
India.
do have the
Really?
concept of mediation. Yeah, we do. But in
I
theory,
was
like I've been
very
to a
amazed.
lot of yeah, it is, it really is. But I've been to a lot of mediation centers, which are, working in collaboration with our High Court and Supreme Court. So in practice, you would see mediators, completely interfering between parties, asking someone to, just quiet down, maybe providing solutions left, right, and center, because it's kind of how things have worked since the beginning. But there is a differentiation between the concepts theoretically.
That's pretty interesting.
Yeah, I mean, the similar practices observed in the UK. You are taught in UK methodology that as a mediator, you don't start suggesting numbers. You're not there to provide solutions. And in some ways, that will be resented. You've got the papers the night before or 2 days before. Are you seriously about to start telling the lawyers who've had this case for 3 years that they don't understand what the liability is about? They don't understand the facts or the law. And I think there's possibly a change in the UK, and that mediators becoming slightly more interventionist, but it's reluctantly and it's late on in the process because it's a knife edge.
Oh yeah.
It's a much more dangerous way of mediating. If you get it wrong, you'll explode the entire thing, and the parties will go home. And so it's difficult. But I think it's highly contextual. You've got to know what the parties are expecting culturally. You've got to be able to read the room and see when you can push and shove and when you can't, and what resistance that you'll meet. One of the most remarkable things I saw in the United States with a mediator judge, retired judge mediator, was it was a $400 million class action. And for some reason I ended up having to leave before the end, but 6 or 7 hours before the parties ultimately settled this case, he told me to within $500,000 where they would settle. And I think that was the product both of vast experience, but also him pushing and shoveling and marshalling everybody towards that figure that he had in mind. That was his figure. This is what he thought, reading the paper, this is what it ought to settle at, and sort of dragooned everyone towards that figure. You have to be a certain type of mediator to do that, and the clients have to be expecting that as well if you're going to be that interventionist. And it's one of the big distinctions that I see between Europe and the States on mediation is the way that the parties negotiate. Nobody really uses brackets in the UK. I don't know if that's a thing in India, but it's a remarkable, I think, really very useful way.
I don't like brackets. I hate brackets.
Well, I've only ever seen it.
Could you help us understand what brackets are? I don't think a lot of us are familiar with that term.
When you get to a point where you're simply arguing about money, and one side's at 100 million, the other side's at 0.
Oh, we love that in India. We call it bargaining.
Yeah, but what you're doing is making a hypothetical offer to the other side. If you will move to X, we will move to Y. And so you've suddenly got if you'll move up to 40, we would move to 60. And it means you've not given away your position. You're still holding on to that. It's just would you hypothetically make that move? And the other side will respond, well, we might move to 50 if you will bring your offer down to 70. Whatever it is. So they're trading in hypotheticals. I'm not the best person to be describing this, but it's commonplace in the States, and there is a whole science of bracketology. You're trying to calibrate where the top of this one is and the bottom of the other one. And it's not necessarily about the middle of the bracket, but it's just the message that it sends. And I think doing all of this sort of without making a definitive offer that's going to make someone run out of the room, offering a range. And this was really eye-opening to me, just following mediations in the States, that everybody was so comfortable with this this way of doing business. It just seemed completely normal, very comfortable, very happy, and actually these brackets come up and down.
Not always.
Well, no, not always. But this is a lot of the conversations I saw between mediators and the parties in caucuses were about where is your top and your bottom of this bracket going to be. And they'd say, well, I think, we'll offer that. And he'd, no way is that the top of the bracket. It's got to be this. And, then they'd argue about the bottom of the bracket. And essentially the mediator was almost negotiating against himself. He was telling them the top and the bottom, and he'd go and say the same in the other room. And before you knew it, they'd said the figure the mediator wanted. But that doesn't happen. I know mediators in the UK are very keen to try to get some of this. You trying to sell the idea of brackets is very difficult here, and it by and large not used. In fact, it's so rare that one of the mediators on my panel wrote a blog about the time he was able to successfully sell a bracket to the parties, how happy it made him, how successful it was. It's as rare as that.
I guess my experience, the parties already know what is the whole philosophy about the brackets, and they're saying, no, and don't try to get me into a bracket because it's not going to happen. I'm not going to that midpoint, because the whole point is once the parties agree to it and you move them, so the midpoint is where we're going. And obviously they know that in advance. And by now, everybody knows the strategy, and everybody say, no, don't try to get me into that. So that's what I say. And I was talking to a bunch of colleagues like a month ago, and everybody agreed that they hate the brackets, because once it's pretty hard to get the parties to move, and once they move, everybody is all confused sometimes about, oh no, but I expect him to move this way. No, wait, I moved this way. So everybody gets confused and everybody gets frustrated. So mediators in general, they don't like it. Sometimes they get into it, but they don't like it. But like to Matthew's point, I think is, I guess a mediator, and they have to know at what time they can start offering their own solutions. And obviously they have to find out, and they have to feel that this is the right time to start offering. You're not going to start proposing different options right from the beginning. Obviously you have to be very respectful, very careful. And when you realize, okay, they're stuck here right now, you can ask them, so what about if we do this? And I don't know, in some way, try to work with everyone. And at some point when you realize, okay, nobody's moving, we're stuck here, let's try to come up with different ways. So obviously, it's not something that the mediator is going to do from the beginning. We start proposing different solutions. It's something that you realize that the parties need sometimes, and you need to know when is the right time, the right moment to do it, and how to do it right, without insulting and without offending anyone, because they can get really offended. So you have to be very careful. It's like, really? Do you really think that this is the value of your case? Well, you had to, obviously. And that's what I say, emotional intelligence is one of the most important skills that a mediator can have, because a mediator with emotional intelligence, he will be aware of when, or he will have the intuition to know when is the right time to start helping the parties and providing solutions. That's what I would say.
Well, thank you so much for that very interesting discussion that we were having. And just as we move towards the conclusion of the session, we have a few questions from the audience, which I'd like you to answer. There is a question: is it best to not agree to a resolution towards the end of a negotiation in a competition if the opposite party does not agree to a solution and instead proposes something that is adverse to your client and goes against the instructions provided in your confidential information? What would a judge think of such a situation?
Well, Matthew, you want to go ahead?
Well, I'm only really familiar with the ICC rules, which we're scoring parties in that instance on their ability to collaborate and to move toward. You don't have to settle the thing, but if being judged on your ability to generate momentum towards that, and I don't know if the context of this question, if it's similar rules. But if it's obviously if it's against your goals and counter to your interest, then clearly don't settle. But generally speaking, the judges are not looking for that kind of technical lawyering, if you like. It's more an appreciation of the dynamics of the negotiation and your ability to generate momentum. You won't be scored badly if you either decline or agree to a settlement. That has been my view, but that's purely from an ICC perspective.
Okay. We have another question. Can you, through some examples, tell us what good mediation and poor mediation looks like? I'd like to get an idea of the role and extent to which a mediator can participate or interfere in a conversation.
Well, like, I guess
I think this is
a good mediator is the one. Yeah, a good mediator is the one that understands what is really happening, understands the dynamics of the dispute, understands the personalities involved, understands what the parties need to be motivated to negotiate and to settle, and is very creative, very persistent, very patient, and just keep going and doesn't give up. I think that's one of the most important qualities of a good mediator.
The question was about a good mediation. What is a good process? Is that right?
Excuse me, sir. If I may,
Go ahead.
I'm the one who posed this question. I'd like to elaborate it so that it make it easier for you to get the sense of my question.
Sure.
Say for out of your personal experiences, say you're sitting, you're mediating, you're hearing what both sides are saying. Now, a particular example that, okay, this was the situation, so you said this in response to this. that that qualified as an example of good mediation. Similarly, if you've seen an example of poor mediation, something very tangible from your personal experience, where you could explicitly tell that, okay, the mediator in question said this, and that really ruined the whole thing. And similarly, the mediator in question said this, within this particular situation, and it worked out. And so the students get something they can visualize as a tangible example of, okay, this is what a good mediator looks like. This is what poor mediation might look like. And we might sort of use that as a building block in our model of how we conduct ourselves.
It's a very difficult question, because it's it's not an obvious cause and effect between what the mediator does and says and what the outcome ultimately is. And I see why you're asking the question, but it did remind me of a mediation that I once observed, that I thought was a disaster. And this kind of relates to Ananya's question earlier about justice. This mediation, I'll try and generalize it a little bit, involved a road traffic accident, and it was claims for compensation for injury, and the plaintiff's opening offer, which we were expecting, as Anna was saying, would be an outrage. It would be 10 times what the case was worth. It wasn't. It was half what the insurers had reserved. That was their opening offer, and then there was a pretend mediation, a pretend negotiation, and they settled for even less. And I just thought, my God, this is just horrendous on every level. I've just seen an absolute travesty of justice. I can't believe it's been so incompetently lawyered. There was nothing the mediator could do about it. And I went and asked the plaintiffs on the way out, were they happy? And the injured guy said to me he was overjoyed. All he wanted to do was to pay for his daughter's wedding in 2 weeks' time. And so if he could walk away with the cash, then, I could have got X, Y, and Z. I could have got 5 times more if I'd litigated this for the next 2 years. He knew that. And so, it's very hard to, so what I thought was a disastrous mediation. There's so much that you don't know about people's needs and their motivations for doing things. That it's really hard to say what is successful, what's not, what's good, what's bad. I'm sorry to sound so sort of relativist about all of this, but that's the nature of mediation. There's so much going on that a particular intervention, what's said, what isn't, is hard.
That's all right. I really appreciate what you told me. If I may add, would you have some books or some text that you'd really recommend some up and coming mediators read? Something that really stuck with you.
Well, there's so many negotiation good books, but
like off the top of your head,
yeah, you know what, one that I really like is everyone probably know about Getting to Yes. That is kind of the Bible of negotiation, right? But there's another book that is basically saying the opposite. And I really like the whole concept of this book, because they basically say in the traditional negotiation, everybody expect that everybody's rational, right? And everybody's going to come out with reasonable and rational demands. But this book was saying exactly the opposite, that you had to be prepared to deal with irrational people with unreasonable demands, And that's real negotiation. And that's what I really like this book. Let me give you the name of the book, because that was a really helpful one. And they talk about, in general, about the good negotiation. I can send it to Ananya, and she can send it to you.
Yeah, no problems at all. Matthew, same to
That'd
you.
be perfect.
If you have any list of books or recommendations, we'd love to, relay to our participants later. That's also fine.
Thank you both so much.
Sure.
A couple of things stick in my mind. One more recently published one is by Stuart Diamond called Getting More, and that seemed to be I thought a good up-to-date synthesis of negotiation theory and where it's going, and I think sort of pertinent to today's conversation that I've not been very helpful on, was really how you can incorporate these skills in your daily life and the necessity of doing so, and practicing and rehearsing them. I thought was a particularly good book. There's another one, just for the sake of being provocative, and I can't remember the author's name, but I will find it, but it's called Anatomy of a Mediation, and it's written by a former corporate partner from Skadden in New York, and he comes at mediation from a very different angle from where we have traditionally from negotiation theory and where we have done as litigators. And it's he has his own very kind of asymmetric process where he negotiates in separate with partners to get them into with parties to get them into a sensible zone, and only then put them together, and sometimes not at all. And I just think if you want a different take on something that's been quite successful, that's very unconventional, that's a good book. So I'll have to look at.
I found the name of the book that I'm talking about is Never Split the Difference.
Okay.
It's by Chris Voss and Tal Raz. And another one that I really recommend, and a big believer in that a good mediator, a good negotiator, they need to understand psychology. Mm-hmm. And this is about the psychology of persuasion by Robert Cialdini. I think that is a really good book too, and I really recommend that one too. The Psychology of Persuasion.
Yeah, I've read that. That's excellent.
That one is fascinating to me. I love anything related to psychology and the psychology and the dynamics.
Yeah, on that note, I mean, Thinking Fast and Slow, if you want to.
Oh, yeah. I've read that one.
Is where it all comes from. All the all neuroscience and behavioral stuff is all contained in that. Everybody should read that.
And another book that I really like too is a Kiss, Bow, or Shake Hands. And is more about negotiating with people from different cultures, and I really like that, especially for these international competitions when you have to deal with students and people that is from all over the world, and it's always good to be aware of the cultural differences between everyone, and I really like that one too.
Very well, thank you. You've put a big smile on my face.
Okay.
Thank you.
I'm glad.
Well, thank you so much for all of those recommendations, and we have come to a conclusion of the session. Aditya, I'm just going to ask you to give the closing remarks.
Yeah, sure. Thank you so much, Ananya, for the whole session. It has been really wonderful. Anna, Matthew, it's been a pleasure having you here with us. I think one thing that I could say on behalf of everyone is that the questions being asked by Ananya will go like very gentle, but I was able to get different point of views from both you and Matthew. And it was just amazing to see how, the same thing could be understood and interpreted differently, maybe because of different backgrounds, because of meeting different people or circumstances. But it was just wonderful to hear the varied opinions, both of you. So thank you so much for doing this, and a huge thanks to ECI for organizing the whole webinar. I'm sure the participants have learned a lot from this, and will take away a lot of memories as well as knowledge from this. So thank you so much for everything. Thank you.
Thank you for having us.
Thank you for having us. And I wish all the best to all of the participants. I hope you have a great couple of days ahead. And I really hope that we can all meet in person next year for NINC 2.0.
For sure.